Hello, is it good morning or good afternoon? Good morning, probably. My name is Akiko EJIMA. I'm in charge of this session, Japanese session, so featuring on the human rights in Japan and also Asia. And this session is rather featured on the possibility of the Asian Human Rights Court. And it's really great honor for me to appear as a lecturer as this very established summer course because I participate as a student in quite many years ago. So I'm so happy to come back my sort of lab school and also Strasbourg, although by online. And by the way, my background, this is my university and it's the center of Tokyo. So you can feel a bit of how really bustle of Tokyo. But of course, we have a nicer nature area and also very culturally lovely place as Kyoto. So once the pandemic is over, do come to Japan to enjoy a different culture and history. So let me start by using my slides. So, insight towards the establishment of a human rights code in Asia. And introduction, the topic is a human rights code in Asia. It is true that there is no regional human rights code in Asia, and there is no any sort of specific plan to establish a court in the near future. So I'd like to give you some information and ideas to think of this question, whether it is necessary and also it is possible to have a regional human rights court in Asia. And when I mention Asia, already it is quite problematic because Asia is such a large area and such diversity, and probably there is no element which can bind every country which is sort of situated in the area which is called as Asia as one. So different religions, different cultures, different ideologies. And when you think about the human rights court, regional human rights court, always you think of some similarities, something which is shared by most of the people in that region. Then it might be really difficult to establish such a court in Asia. But I try to explore the possibility by using what we have already as the constitutional law and international law. And also probably the present situation, such as the COVID-19 and human rights. It is probably the first time for the human beings to watch that every life, or I should say that every loss of life is counted every day and compared by country, by region. Even you have the ranking, which country is doing better, which country is not necessarily doing well. And then when you talk about the life of the people, it is the responsibility of the government to protect the life of each individual in the country. And particularly vulnerable individuals and groups are exposed under the pandemic. Healthcare workers, essential workers, elderly, women, LGBTQ, children and young adults, persons with disabilities, foreigners and ethnic minorities, prisoners, artists, athletes, etc. And by mentioning that, are there unique Japanese or Asian problems? Actually, I don't think so. What we have here in Japan might be observed in other countries. And then, how do governments respond to the problems? Are there unique Japanese or Asian approaches? Here, I might say yes. For example, the Japanese government, in order to manage control the pandemic, the government requests the people to stay at home, but without penalty, without punishment, without any enforcement. So this is a kind of soft constitutionalism. And then there might be some differences in implementation and also oversight mechanism. As I said already, the Japanese government did not bind the people's activities by law. Therefore, if the people think this is a problem, but it's more difficult to bring the case to the court. And then I repeat the same question. In this situation, is it necessary to have a regional human rights court in Asia? Is it possible to have a regional human rights court in Asia? And this time, due to the time constraints, I can't explain the rule-based model and the internationally grounded model, but I just want to mention that there are some similarities in the Asian constitutions. Either they are rule-based model or the international grounded model. The rule-based model, Japanese example, is a very good example. The Japanese constitution was installed because Japan surrendered and Japan made a new constitution under the occupation. And after World War II, many Asian countries became independent and they made a constitution with the help of the international organizations or foreign countries or legal advisors or even NGOs. So let me start from the reality check. Is it necessary and possible to establish a human rights court in Asia? I think you have already learned many international human rights treaties, UN level and the regional level. And there are 18 international human rights treaties, and according to the website of the OHCHR, then this is the situation right now. And then when you see the Asian area, yes, it is true that the Asian area, Asian countries are a little bit far behind in comparison to other countries in terms of ratification. But then when you move on each treaty, for example, ICCPR, which is one of the main human rights treaties at UN level, then when you see the left map, then, well, not most, but quite many of the Asian countries already ratified ICCPR. But when you look at the lower map, then optional protocol to the ICCPR, which enables the individual communication to the one of the International Human Rights Committee, then it's quite orange, which means that most of the countries still has not ratified this optional protocol. So the individual cannot bring the case, the complaint, the individual communication to the Human Rights Committee. Only the state reporting is the only way to implement the Human Rights Treaty. So the map is so small, but the South Korea and Philippines ratified optional protocol. And another example, the Convention for the Rights of the Child. When you see the left map, now most of the countries ratified this treaty. Only the United States has not ratified yet. But when you look at the lower map, suddenly the map became orange, which means that most of the countries has not ratified optional protocol. So this is the reality. And then I just want to add another map, which is about International Convention on the Protection of the Rights of all Migrant Workers and members of the families. So when you see most of the developed countries has not ratified this treaty. And the countries which actually send the migrants to the developed countries, global north, are interested in this treaty. So this is quite the deplorable reality. So now the human rights protection mechanism by constitutional law and international law. And here, I'd like to emphasize why non-ratification of the optional protocols, so individual communications, matters. So this is just a model. Right now, still, to protect human rights is the main obligation of the government. The international organization, there are many organizations and many treaties, but they can't take over the role of the domestic government. So rather, the current situation is the international system try to support, promote, and push the domestic governments to implement human rights. So, for example, in the case of Japan, Japan takes minimum approach. So it has not ratified optional protocol. So individual cannot bring the individual communication to the treaty bodies. So rather implementation is more general level, such as how far governments implement the contents of the treaty, the rights in the treaties. And as a comparison, I want to show the UK situation. UK ratified the European Convention on Human Rights, one of the old member states, but it has not incorporated the European Convention on Human Rights, which means that the rights in the European Convention are not sort of domestic rights. So the government could ignore those rights. Then the result is, until 90s, the UK was most sued at the European Court of Human Rights. And then the Labour government, which was established in 1997, finally they made 1998 Human Rights Act, which means that they sort of install the content, the rights in the European Convention on Human Rights as the rights in the UK. Imprecisely, the the public authorities, except for Parliament, should act incompatible with the European Convention on Human Rights, and which creates the structural change. Parliament established the Joint Committee on Human Rights, and at the judiciary, the House of Lords as the highest court now changed into the Supreme Court, and which check the compatibility with the European Convention on Human Rights. And also National Human Rights Institution as the Equality Human Rights Commission was established. So there are more dynamic between the constitutional law system and international law system, which means more implementation occurs. So in the context of Asia, I try to find the starting points. For example, in the case of the European Convention on Human Rights, why could they have such a drastic document which enabled the individual to sue their own government to the International Court as the European Court of Human Rights? What could be possible in Asian region? In the context of Europe, probably the World War II and also Holocaust, and then the Cold War as the conflict between the Eastern European countries and Western European countries. So there is a strong motivation to have such a mechanism. So what kind of motivation you can find in Asian context? Well, recently, there are several interesting trends and phenomena. Probably one of the strongest and structural one is the ASEAN Intergovernmental Commission on Human Rights, which was inaugurated by the ASEAN leaders in 2009 at the 15th ASEAN Summit. ASEAN commitment to pursue forward-looking strategies to strengthen the regional cooperation on human rights. The ASEAN Intergovernmental Commission on Human Rights is designed to be an integral part of ASEAN organizational structure and an overarching institution with overall responsibility for the promotion and protection of human rights in ASEAN. So this is the first structural organizational existence to promote human rights. Although their members are nominated by the respective governments, and also this is not the court, so they have the meeting and discuss about the human rights issues in Asia and report to the ASEAN foreign ministers. And then another more interesting sort of initiative, which is taken by the Constitutional Court of the Republic of Korea. At the World Conference on Constitutional Justice, which was held at Seoul in 2014, the Constitutional Court of South Korea declared Seoul Communique. And it says, the participants were informed about the initiative of the Constitutional Court of the Republic of Korea to promote discussion on human rights cooperation, including the possibility of establishing an Asian human rights court based on international human rights norms in order to enhance human rights protection in the region. And South Korean Constitutional Court made another interesting initiative as the Association of Asian Constitutional Courts and Equivalent Institution. The abbreviation is AACL, which was established in 2010. Currently, there are 19 member states: Afghanistan, Azerbaijan, Bangladesh, India, Indonesia, Kazakhstan, Korea, Kyrgyzstan, Malaysia. Sorry, I made two Malaysia, this is my mistake. Maldives, Mongolia, Myanmar, Pakistan, Russia, Tajikistan, Thailand, the Philippines, Turkey, Uzbekistan. Again, isn't it interesting? Here, the Russia is included in this AACL. And I just want to show the objectives and functions of this AACL because there are interesting points. For example, objectives: the protection of human rights, the guarantee of democracy, the implementation of the rule of law. So human rights, democracy, rule of law. This is a trinity for the European Code of Human Rights and the European Convention on Human Rights, and probably European Union as well. So there are some similarities. And functions, sorry, this is not the court itself. This is the association of the courts. So the main function is the sharing, the information, and also experiences as the Constitutional Court. But by sharing the issues, important constitutional questions, which includes the human rights, then they can learn each other and they can understand each other, and probably which might create the starting point to establish a kind of regional court mechanism. And also Global Alliance of National Human Rights Institutions. This is a global thing, but then there are 29 national human rights institutions in Asia. And finally, this is a more sort of kind of private initiative as the Asian Human Rights Court Simulation, which was established in 2018 with the collaborative efforts of Asian civil society and 13 judges from 10 different jurisdictions as Bangladesh, Hong Kong, India, Japan, Malaysia, Republic of Korea, Singapore, Sri Lanka, Taiwan, Thailand. In reality, they are academics or the NGO members or retired judges or so on. So to some degree, they have some experiences as a judge or the advocate or the legal expert as the law professors. And they chose one real case from Taiwan as Cho Ho-shun, Taiwan. He was arrested in 1988, sentenced to death, and has been imprisoned more than 30 years. He claimed his conviction was based on confession. The confession was, sorry, this is a font of mistakes, but the confession was being proved to have been extracted by torture and coercion by prosecutors and police officers. So this was a quite serious human rights violation in terms of criminal rights. And the result is the sort of this moot court admitted that there is a violation of human rights. And of course, this is just the imaginary court, doesn't exist reality. But it is quite interesting experience because we discuss beyond different jurisdictions. Some jurisdiction is based on rather common law system, the English law system, and other jurisdiction is based on more European continental law system. And there are many differences, but still we can discuss the human rights issues by relying on international human rights treaties and domestic constitutional law. And so this experience rather taught us that, well, there is a good point to have the regional human rights court. And probably it is possible if we continue to have conversation and sharing experiences and information when the time has come. And another sort of unexpected additional contribution is the result of this moot court. One of the brothers of the victims, he attended the whole proceedings of this moot court. And at the end of the court, he commented that by seeing the sort of international or regional efforts to discuss the issue, he appreciated this effort. So even it somehow gave the opportunity to have the restorative justice. So from here, I would like to give a new approach. A human rights court in Asia is not the only way to achieve the goal. The goal is effective human rights protection. So how to encourage the government? As I said already, that in order to encourage the government to implement human rights in reality is the most important point to improve human rights and to have the effective protection of human rights. Unfortunately, domestic constitutional system has a limit of separation of powers and rule of law. For example, sometimes the Supreme Court or the Constitutional Court is reluctant to deal with the case, and the legislature is ignorant of the existence of the human rights. And executive may not be encouraged to search for human rights because they have already enough works. So in this case, international input is very useful. But again, the courts sometimes works as a naming and shaming. Therefore, some countries are reluctant to join this system. So probably we can start from the sharing good practices. And once they are accustomed to the sharing the good practice and ready to install more effective, more probably intervening system as the court, then they might start to discuss a regional court, the possibility of a regional court. And in order to share in good practice, I think evidence-based research is very, very important. Otherwise, it might become very political, or it might be groundless claim. So evidence-based research is important. And in order to have good evidence, of course, the parties who are involved in the case has to participate. They are the most first-hand information giver. And in order to make them participate, the empowerment of the people is very important. And probably easy read material is a good approach for the first time. And once all the sort of stakeholders can participate in this circulatory mechanism, then more and more issues would be discovered and more issues be treated in this circulated mechanism. So it's not like they, what do you call it, they are hierarchical system. The court is the court has the final say to decide what is right. No, it's not that way. Rather, everybody has some limited function, some limited power to decide something. But then, once it is decided, then the case goes to a different stakeholder, and they might treat in a different way. But in the end, in the last sort of stage, every question may get an answer by some way. And I skip this part because slowly I have to think of the time. So a possible alternative perspective, as I said, or as I mentioned already, the court is not the final sort of solution. Rather, system should be circulated and goes on and on and on. And also, the sort of dichotomy way to describe the problem is not so helpful, like West versus East, or Asia versus non-Asia, or authoritarianism versus liberal democracy. Instead, we can see the phenomenon as a spectrum, and each stakeholder has a voice, and particularly the victim or the person whose right might be violated, if they are empowered and to say something to someone, to some institution, either domestic institution or regional institution or international institution, then his or her problem is discovered and is to be dealt by some institution, by some organization, or by NGO, or by media, or by academia, or company, whatsoever. So I'd like to make a sort of brief conclusion, tentative conclusion. So not copying the established regional system is not the answer for Asia, is my view. Rather, sharing information and experiences could be the first step to move forward for the regional court. We are at crossroads, and after the pandemic, what kind of society we might witness? Leave no one behind, which is often told by the government, the international organizations, NGOs, but can we really achieve this goal? And in order to achieve this goal, a grand theory doesn't work. Rather, small steps, accumulation of small steps are really important. And again, empowerment of individuals are really, really important. Okay, temporarily I stop my talk. Thank you very much for your patience. And I'm happy to have your question. So I stop. And if you'd like to ask question, either you can talk directly or you can write down your question by using the chat mechanism. Or you can probably give me a comment by comparison your region or your country versus Asia or Japan.
Good evening, if I may.
Thank you. Good evening and good afternoon.
I'm from Latin America, in fact, and
excellent.
And for me, it has been very curious I was very curious to see why there was not an Asian court. If I understood, one of the main reasons is that many countries didn't have adopted or ratified the optional protocols for individual communication. So from that, it means that there will not be we wouldn't have been there will not be very successful if to follow this model. But on the other hand, at the end, you said that one of the possible alternatives or approach to have is to empower individuals. And also you mentioned that it is not, but one of the things that maybe countries are reluctant is that they don't like the naming and shaming, how it happens sometimes at the Human Rights Council, for example. And so it seems to me quite paradoxical, because if we have a court and if it would be only between the states, we could have the problem to have some political issues, you know, like following the model of the International Court of Justice that is almost between the states only. But if we have a court with where individuals, usually you will not have this naming and shaming, and it would be like to empower individuals. So it's just that it seems to me quite paradoxical.
Yes, yes, indeed. I agree with you. Your analysis is very, very good. And first of all, I think motivation is very important to have such a regional court. And at this moment in Asia, there is no motivation, particularly the side of the government, because government usually don't want to be criticized in the international community. So the result of non-ratification of the optional protocols shows the reality that at this moment, very few countries, like probably South Korea, but other countries may not be interested in establishing a regional court. But as I said, probably there are two ways. There might be a drastic change in Asia, which pushed the government to accept the regional court. This is the case of the European countries and other regions as the Latin America or Africa. But at this moment, there is no such incident to accept such a drastic court. So I take the more slow and progressive approach to have the understanding and to have the more communication and trust among the countries of Asia. And also I have to emphasize that Asia is not the one region. There are so many different, rather sub-regions. And for example, probably have you attended the Professor Nakanishi's lecture yesterday? Okay, then I'll explain. Japan was rather developed so fast, already started the modernization at the end of the 19th century. And at that time, Japan incorporated, sort of absorbed all the Western legal system, literally copied them. So it's already the European legal system is not sort of aloof or different system. It is the Japanese system as well. But you cannot say the same thing with other Asian countries. Therefore, in my view, it may not work to say Asian system or Asian mechanism. There are such a diverse and such a divide gaps in terms of economy or in terms of probably political power and so on. So as I said already, the trust is very important to work the regional mechanism, but still so many differences existed which hinder the trust. And particularly this sort of dichotomy as the nation first or internationalism, then at this very difficult situation, particularly vaccination racing, which create the divide among the countries, the rich and poor, then it's a really difficult time. Therefore, I rather more probably relying on the taking time and establish the more communication, understanding, and so on. Therefore, AACL, this Asian Association of Constitutional Courts, this is really, really interesting because it's the first time to establish such a system among constitutional courts and equivalent of courts. Unfortunately, Japan is not involved. Again, when you see some kind of Asia is not one region, but as a starting point, it's nice to have such framework of the courts, which might provide a starting point. And also, I would like to mention another interesting fact. This World Conference of the Justice is supported by the Venice Commission of the Council of Europe. And also this AACL is again supported by the Venice Commission. So there is already a kind of dialogue or networking or exchanges between, for example, Europe and Asia. And probably why not between Latin America and Asia? Probably it should start now to have more dialogues. And then the Asian countries might learn from Latin American experiences, inter-American court. And then some Asian countries might appreciate some achievement of the inter-American courts. So not just only the European Court of Human Rights, but there are many other examples. So I think it is a time to enrich our experiences. So are there any questions? Can I ask any of you, what is the image for the Asia or Asian countries? Do you think the human rights are violated? Or do you think the democracy in Asia is questionable? Or the independence of the court is weak? What do you think? Yeah, just an impression. I'm happy to have your impression upon Asia. Anyone who wants to?
Well,
I may try and answer. Like you said, it's extremely diverse. The situation in South Korea or Japan is certainly quite significantly different from the situation in Iran or Saudi Arabia, for instance. So in terms of human rights, I would say that perhaps they tend to be a little bit more respected in Eastern Asia than in Western Asia, generally speaking. I think Japan. I don't know much, even though I'm in fact part Japanese. I'm from Canada, but I'm part Japanese. So my impression, yeah, my impression is that there's a certain, I think there's a certain willingness, maybe, to respect human rights, but it's more perhaps in abstract. It can be seen by the fact that Japan has ratified many treaties, but only a few optional ones. It seems based on your presentation, it seems like South Korea is perhaps the most progressive one, perhaps the most progressive country in Asia. Yeah, I did not know about that. But I think in theory, on paper, some Asian countries, mostly Eastern Asian, maybe, tend to be there's a certain will, but the willingness to put it to implement it to make it concrete tends to be weaker. And I don't know much about Western Asia, the Middle East, but I think it tends to be more problematic over there, and also and I think certain countries such as perhaps Kazakhstan, Kyrgyzstan, I think they tend to be relatively progressive. I'm not sure, but on certain areas at least. So yeah, these are the first thoughts that come to mind.
Thank you very much for your analysis and comments. I really appreciate them. And you're right that there are differences, but at the same time, it might be helpful to see each individual. For example, women in Japan, women in South Korea, women in Saudi Arabia. Someone might say, well, the women in South Korea and Japan might be more protected and equality is guaranteed. Oh. But actually, unfortunately, Japan gender gap index, it is ranked now 120 something among 156 countries. So this is an interesting point. We tend to speak in a more general, abstract sort of sense. But when you see the individual, when you see a stakeholder, then there are some similarities of the problems and also similarities of the solution. And once the victim or the stakeholder thinks, oh, this is a problem, then how can we change? Then he or she can learn from other countries' experience, other people's experience. And on that level, it's not necessary to have the court to strike down the legislation. Rather, there is a thought, there is an experience. Let's talk about it and let's see which way is the most effective way to change. And then slowly, accumulation of the experiences, then it might produce a regional court. So that's my argument today. Although someone might say, well, it takes many years and it's not sort of decisive, it's not sort of substantial. So I accept the sort of criticism upon my approach. But anyway, thank you very much indeed for your comment. And so the start of this course, should we have to end on time? 45?
Yes, please. I think we're going to.
Okay.
Thank you very much for your presentation. It was very enlightening. And thank you
very much for your support.
Thank you.
Thank you very much for everybody. I wish you good luck and enjoy the summer courses. And one day you have a chance to visit Strasbourg and probably Japan.
Thank you very much.
Stay healthy.
Thank you very much. Bye.
Bye.
Bye.